Hello and welcome. I am Professor Raman, and in this module you will study about the special tribunals established in Lebanon, Bangladesh, Iraq and East Timor. You will also learn about the disputes in the particular regions and in the jurisdictions which led up to the establishment of the tribunals. The mode of instruction that we will follow will be similar to the ones that we have used for the ECCC, for the Special Court for Sierra Leone, etc. in past modules. Let us start with Lebanon. The driving force behind the creation of the Lebanon Tribunal was France, which was keen to establish the Special Tribunal for Lebanon for a number of reasons. Its historical ties with Lebanon, along with a close personal relationship that had existed between Hariri and Jacques Chirac, who was the then President of France. The French government accommodated concerns of other permanent members of the Security Council to have this tribunal established. It was initially the Special Tribunal for Lebanon, which was originally visualized as a hybrid tribunal to be established by a bilateral treaty between the United Nations and Lebanon, which followed the model of the treaty establishing, for example, the Special Court for Sierra Leone. This you have studied in a preceding module. This mission is heavily supported by the United States in many substantive ways. The jurisdiction of the Special Tribunal for Lebanon encompasses only the assassination of Hariri and other related attacks between October 1, 2004 and December 12, 2005. Once again, there is a temporal limit on the jurisdiction of the tribunal. The tribunal can take jurisdiction over subsequent related attacks only with the specific consent of the Security Council. Any member of the Security Council may veto jurisdiction over acts committed after December 2005. The specific focus of its jurisdiction lessens the chance of mandate creep and is backed up by the requirement of Security Council authorization for expanding it further. So, the Special Tribunal for Lebanon is a tribunal of international character, whose primary mandate is to conduct trials for those most responsible and accused of carrying out the February 14, 2005 attack, which caused serious casualties. The former Prime Minister of Lebanon, Rafiq Hariri, was among the 22 people killed. But the STL is neither a United Nations court nor a part of the Lebanese judicial system. In this regard, it is quite different from other hybrid tribunals that we have discussed. The tribunal tries people using Lebanese criminal law. It is the first tribunal of its kind to deal with terrorism as a discrete, defined and special offence. The STL was originally envisioned as a hybrid tribunal to be established by the bilateral treaty between the UN and Lebanon that we have spoken about. This was modelled after the treaty establishing the SCSL. Once again, France was the driving force for the establishment and the drafting of this treaty. The jurisdiction of the STL covers only the assassination of Rafiq Hariri, and once again the jurisdiction is defined temporally. Not only is the jurisdiction defined temporally, the subject matter of the tribunal is limited to terrorism. It is the first international tribunal to try crimes under Lebanese national law for an offence which is categorized as an international crime, that is terrorism. It also looks at offences against life and personal integrity, illicit associations and the failure to report crimes and offences. We move on now to the second special tribunal under our consideration. This is what is known as the International Criminal Tribunal, the ICT of Bangladesh. An act called the International Crimes Tribunals Act, ICTA, was passed in 1973, whose aim was to provide detention, prosecution and punishment to persons for crimes against humanity, genocide, war crimes under international law. The ICT was a vital contribution to the development of international criminal law during those times. However, several legislative and/or executive orders effectively halted the trials and granted effective immunity to certain select groups. The Bangladeshi citizens to be prosecuted by the mechanism of the International Criminal Tribunal enjoyed impunity for over 40 years. What was the purpose of this tribunal? Crimes committed during the 1971 war concluded by the secession of East Pakistan from West Pakistan, forming the new independent sovereign state of Bangladesh, is the main motivation behind the International Crimes Tribunal. The tribunal was established on paper in 1973. The armed conflict arose out of an increasing discontent in the East and a national election following a referendum won by the Bengali nationalist leader Sheikh Mujibur Rahman. This liberation war in 1971 is still considered to be one of the most gruesome humanitarian crises in the last century. The 1971 War of Liberation, as Bangladesh likes to call it, is considered to be one of the most severe humanitarian crises which had widely documented massacres, lethal crimes, forceful displacement, destruction of life, property. The systematic collection of data on casualties was never made. But a popularly accepted figure within Bangladesh and also reported in several external sources state that over 3 million people were either killed or tortured. Approximately 200,000 women were raped in the concentration camps, many of whom were subjected to forced pregnancy, whereas a great number, almost 10 million, were also internally displaced and forced to flee to India. Even today, they are seeking refugee status. The International Crimes Tribunal was established by the Act of 1973 to tackle these crimes committed during the 1971 war, which resulted in the formation of the new state. However, the success of the ICT has been circumspect because its operation started 40 years after the Act was adopted. Let us move now to the third tribunal that we are looking at in this module. This is the Tribunal for Iraq. The Iraqi Governing Council created the Iraqi Special Tribunal, whose acronym is the IST, in December 2003. The statute of this tribunal was revoked and replaced by an amended statute that renamed the Special Tribunal as the High Tribunal by Iraq's Transitional National Assembly. This special tribunal has jurisdiction over all Iraqi and non-Iraqi residents in Iraq who are accused of crimes, specifically genocide, crimes against humanity, war crimes, or violations of certain Sharia laws in Iraq. The IST is not an international court, but it certainly follows international elements. It also deals with both domestic and international law and largely follows the international fair trial standards. In Saddam Hussein's case, which was the first legal hearing conducted by the tribunal on July 1st, 2004 in Baghdad, it allowed the presence of people apart from the defendants. This trial started in October 2005. Though it has elements of an international court, it had to follow domestic law in order to win the support of the Iraqi people. It is also unique because it is situated in Baghdad. In fact, all the tribunals that we speak about in this module are located within the state of origins of the history of the conflict. Now, the war crimes in Iraq included the attack on the Iraqi Kurds, a forceful ejection of the ethnic minority from Kirkuk, and repression of Arabs and Shia Muslims. There was undocumented excessive usage of chemical weapons during the Iran-Iraq conflict, which was a violation of the Geneva Protocols that regulate humanitarian conflict. Systematic and gross abuses of human rights and other violations constituting war crimes and crimes against humanity took place between 1990 and 1991, the period in which Iraq had forcefully occupied Iranian territory, especially Kuwait. On the 22nd of May 2003, the United Nations Security Council adopted Resolution 1483, declaring an urgent need for accountability for the crimes and atrocities committed by the previous Iraqi regime. The Interim Governing Council, formally established by the Iraqi Special Tribunal, was appointed by what is known as the Coalition Provisional Authority, or the CPA. The United States, interestingly, led the CPA on December 10, 2003 and promulgated Order Number 48. This order explicitly delegates the full legislative authority to the Governing Council of the CPA. The importance of this tribunal is in its stated purpose, that is, to expose the crimes committed in the territory of Iraq from the 7th of July 1968 until the 1st of May 2005 against the Iraqi people and people of the region, and the subsequent brutal massacres based on ethnicity. To establish a national supreme Iraqi criminal tribunal made up of Iraqi judges with high experience, competence and integrity, and with the power to try these criminals. Its purpose is also to reveal the truth and the agonies and injustice caused by the perpetrators of such crimes. It hopes to protect the rights of Iraqis, to redress injustices committed against them, and demonstrate heaven's justice as it is put in Sharia law. The most interesting feature that sets this tribunal apart from others is this mix of Sharia law with international law, which has somehow received the acceptance of the Iraqi people. Our final example for today is East Timor. In East Timor, a series of queries were put forward after the withdrawal of the Indonesian military in September 2009, which were held by Indonesian authorities and the United Nations. Hundreds of civilians had been slaughtered in the war. Property had been destroyed on a very large scale. Thousands of people were ejected from their homes. East Timor had been successively colonized by two colonial powers, rapidly following each other. The UN set up an organized investigative team. Reports alleged that the militias were financed and also equipped with all the necessities by the departing government of Indonesia, and that the Indonesian military under Suharto and civilian authorities in East Timor were working in cooperation. The violence erupted into a coup during 1999, and there was a brutal rampage by Indonesian military and pro-Indonesian militias in East Timor, in the capital city of Dili, following a referendum in September 1999 in favor of East Timorese independence. A little credit must be given to the recommendations and steps taken by the United Nations, setting up the best way to assess special tribunals and perform subjective qualitative tests, which once again is an important step to attain timely justice. All of this came in the form of a UN-sponsored International Human Rights Tribunal's white paper, which agreed to allow domestic attempts in Timor Leste, which is the French name for East Timor, Indonesia and Timor, to provide justice for the crimes committed in the past, provided that the United Nations can monitor the process. This was important to establish credibility in accordance with international human rights standards. After gaining independence in 2002, the special panels continued under the authority of the new government of newly independent the sovereign state of East Timor. However, in 2005, due to the withdrawal of much of the UN infrastructure and officials, the special panels were compelled to suspend their operations. The special panels suspended their operations indefinitely, and we never knew what came of the East Timorese justice process. Let us now consider what we have learned from the establishment of these four related but very different stories of the establishment of tribunals. Like all courts of international jurisdiction before, these special tribunals have faced significant challenges and hurdles. These have specifically undermined and threatened their potential of adjudicating in a just and fair manner. With the help of the United Nations, which appears to be a common factor almost uniformly across all of them, and other local bodies, local authorities, the constitution of tribunals has now become a little easier. However, as you see from the history explained above, these tribunals are half national and half international, and in some other cases they are a strange admixture of local laws, municipal laws and international laws. Their subject matter jurisdiction is different and their temporal jurisdiction is different. Critics have also remarked that these special courts are a second best substitute to full-fledged international courts. On the other hand, nationalists say that national courts ought to be prosecuting national crimes. However, political situations don't always allow this. In the absence of political cooperation, the international criminal tribunals and the special tribunals have become the model for adjudicating. These models should not be indicted by the failures of implementation of the processes of these tribunals, because they still hold a promising future. In recent years, the thought of the ICC as being the sole resolver in the world of international criminal law has slowly and gradually withered away. The prospects of the intervention by this huge international body have become simultaneously slim and varied, because international community seems to prefer the establishment of special tribunals. There is a significant democratic deficit in the ICC for various reasons, but the special tribunals, since they don't usually require the consent of the entire international community, are seen as slightly more efficient. However, they also rely on judicial assistance and international cooperation with other international organizations and states. With the account of the warring states given above, it has been observed how gradual was the process of creation of these ad hoc and special tribunals in times of urgency. However, one also has to make sure that these tribunals should succeed in their noble goal of dispensing justice that is free of any political or ideological fetters, and that their remarkable beginnings are carried forward in the same manner as they started. For this purpose, the tribunals ought to continue to communicate with all concerned political organizations, which could organize, encourage and support them. These tribunals should also be in close contact with the critics for garnering their assistance too. In conclusion, one might say that states that tackle conflicts don't really have the national remedy open to them anymore. States that are recovering from repressive regimes would face finite difficulties in coming to terms with their past. However, each situation is different from every other situation, and it requires a specific solution. But this move towards encouraging greater domestic involvement is still important to some extent to avoid the allegation of vengeance or bias or unnecessary focus upon one region or group by the international community. This step towards individual accountability for international crimes is firmly based on the underpinnings laid down long ago at Nuremberg, when it was actually recognized by only by such accountability can international criminal law be enforced. The international tribunals are taking this mission forward. Thank you.